Hello and welcome back to Rasmussen Law's YouTube channel. My name is Matthew Rasmussen, and today what I'd like to do is discuss a topic with you that often comes up in the context of drafting a last will and testament, and that is, should you name a loved one or professional as the executor or personal representative of your estate? Now, obviously before we get into this, this is only meant to be sort of a thought-provoking exercise, something for you to think about before meeting with an attorney to actually go through and do your last will and testament. It is not meant to be legal advice. I don't know the specifics of your situation, obviously, since this is sort of a one-way conversation on YouTube. So please keep that in mind. You should not rely on this as legal advice, and this is really just something for you to start thinking about before you meet with an attorney who's going to be able to go through all your specific circumstances and the facts pertaining to your case and be able to make a recommendation. You know, in this case, I think a loved one is much more efficient, or in this case, maybe we should go with the professional. So I can't give you that advice over YouTube. You'd have to come in and meet with us. So please remember, this is just meant to be thought-provoking, and not meant to be legal advice. So with that, I think the first thing that we should do is talk a little bit about what an executor actually does. The executor is the person responsible for administering a probate estate. An administrator is like an executor, but they're responsible for administering an intestate estate, which means someone that passes without a will would have an administrator. Someone who passes with a will would have an executor. Since this conversation is in the context of a last will and testament, of course we're going to be talking about an executor. I may from time to time use the term personal representative, which is sort of the generic term for either one of those, just so you don't get confused. Either executor or personal representative, I'm talking about the same person. So what does this person do? Like I said, they're the person who administers the estate, which means that they go to the surrogate in New Jersey, they get appointed, whether it has to go before a judge or the surrogate of the county can do it. It's a topic for another video altogether, but they get appointed, and then after they're appointed, they're issued letters testamentary, and they take those letters and then they can marshal the assets of an estate, which is to say they bring all of your lifelong savings, your car, your house, so on and so forth, into the estate. So they'll sign it over into the estate of the decedent. From there, they have to pay out first all of the debts that you left behind. So then they will, pay out JCP&L, PSE&G, the electric company. For those of you who are maybe looking at this out of state, those are our electric companies in New Jersey, your credit card bills, so on and so forth. So after the executor or personal representative pays out the debts, they then do an accounting of exactly how much they took in, how much they paid out, and then, perhaps most importantly, how much they can pay to each of your beneficiaries. So whether that be children, grandchildren, whatever, it doesn't matter. And the executor will actually form a informal accounting usually. Some cases they'll do a full-out formal accounting, which is much more expensive, and we try to avoid that, but it'll allow the beneficiary to sort of look over the shoulder of the executor and double-check what exactly they've done over the past 6 months, year and a half, depending on how complex the estate was, and make sure that everything's on the up and up. Once the accounting is approved by the beneficiaries, they then get the distributions from the estate, which means that the executor signs checks over to them, which is their distribution, their inheritance. From there, the executor will take actions to close out the estate, file whatever bonds he has to do with the court, close out the estate, and that's the end of their responsibilities, generally speaking. So now that we know a little bit about what the executor or personal representative actually does, we return to the question, well, should you name a loved one or a professional as the executor? Now, generally speaking, I will tell you that my preference is to name a loved one as not as the beneficiary, of course they would be the beneficiary, but as the executor of the estate. And why is that? Well, first, most loved ones will waive their executor commission. The executor for all of the work, and trust me, there is quite a bit of work entailed. Imagine it, like we just said, setting up a business and then closing down a business. So there is a certain amount of work, and they're entitled to a commission. So usually a loved one will just receive their inheritance and they will waive their commission. Other times, however, they will take a commission, but sometimes that can be a cost savings to the estate. Another reason to name a loved one is there's a certain societal expectation, I believe, on behalf of the people you leave behind, that one of them will be the executor. Sometimes it's the oldest child, sometimes it's the oldest male child, depending on the background of the family. But nonetheless, there is a certain expectation that will happen, and not that we should always go with societal expectations on these things, but sometimes it causes less conflict to actually go forward with the societal expectation. So those are some of the reasons that I would lean towards naming a loved one as the beneficiary, I keep saying that, a loved one as the executor. And I was going to save this for last, but I'll put it in here right before we talk about the professional. If the loved one chooses, they can actually hire a professional to administer the estate for them when the time comes. So that's really the most important part for me as a planning professional, as an attorney. You give that flexibility to the person to decide at that time. Maybe at the time of the passing, your executor has 3 toddlers running around the house or something like that. Maybe they have grandkids of their own, who knows, and they just don't have time to handle the estate. Well, they can then contact a professional such as myself, or some banks will do it, CPAs, so on and so forth. Usually it's an attorney. And at that time say, you know what, I really don't have time to do this. Please handle this for me. So you're allowed to preserve a certain amount of flexibility. Now, with that said, let's talk about the benefits of a professional. First and foremost, a professional is going to be the most efficient person to carry out the administration of an estate. A professional has probably done this multiple times, maybe even hundreds of times before. It's what they are engaged in as a business, so they have systems in place to efficiently move the probate through the correct courses of action. A loved one or a layperson is going to have to do research. They're going to have to figure out, what the next steps are before they take it, and that will delay, not usually by an awful amount, but it will delay the administration of the estate. So that's one positive for the professional. Another positive for the professional is, as I mentioned, this is a lot of work. The closest metaphor, I suppose you could say, for an estate work or for probate administration is starting a business. You have to go to the state, you have to get it approved. There's paperwork that needs to be filled out. Sometimes there's insurance in the way of a bond that needs to be filled out. And then you sort of conduct business, and then you close the business down. And you're doing this all within a year if everything goes well, but sometimes it takes much longer than that, depending on what type of challenges you face in the estate. So, although the executor is compensated, generally speaking, they would have been much better off from a time value of money perspective if they had simply hired a professional to do it for them, and then gone about, doing whatever it is they do for a living and just checking in later. So that's the second reason. And the third reason is some estates are very, very involved. There's going to be tax consequences to a lot of estates in New Jersey. There's going to be challenges to the will, perhaps, things like that, that the executor really shouldn't face alone. And if you already have named a professional, they're going to be able to both identify those challenges probably before they even arise, but most importantly, they're going to be able to effectively deal with them as they come up. So there is a lot behind naming a professional to handle the estate. I just usually recommend naming a loved one as the executor, and that gives them the flexibility later on to determine whether or not they want the professional involved. Because we always try to preserve a certain amount of flexibility. That's the best way to do it, in my opinion. Now, granted, there are circumstances where I will recommend naming a professional as the executor. Some of those considerations might be if there's a lot of strife within the family. If it's not a happy familial situation, there could be a certain amount of resentment that builds up because one person was named the executor. So in those types of situations, sometimes I will advise, maybe it's best that we name a professional. It could be anyone you like, but I just think, in this situation, hypothetically speaking, of course, in this situation, maybe, child one will get too much work, or child one will get resentment built up against them, and that will end up in litigation. We don't want that. Let's just name the professional. Another instance that comes up fairly often, actually, is when a client comes in and they say, I have a relatively perfect family at home, but I don't want to be a burden. I don't want anything to occur that will make my children do work or anything like that while they're going through the grieving process. So I'm just going to take the decision away from them, and I just want a professional to do it from the beginning. And that's another perfectly valid reason. That way the child doesn't have to feel, maybe not guilty, but doesn't have to make that decision. Should I be spending the money on the professional, or should I not be spending money on the professional? So that's another thing to consider. In regards to money, which of course always comes up, some professionals, including our firm, will cap the professional fees to the executor's commission. And we do that in about, I would say, probably over 95% of the administrations that we do. Sometimes, there's a one-off situation, so I can't say in 100% of the situations, but in almost every case, we will cap the fees at whatever the statutory executor commissions were. So this allows the best of both worlds in some scenarios, you might say, where you get the professional help, but there's no difference to the estate, because remember, even if a loved one were to do the administration, they would be entitled to that commission. So you don't have to worry about wild and rampant attorney's fees as long as there's no litigation involved or anything like that. The executor fees will just come out as they always would have, but instead of going to a loved one, they will go to a professional, which would be, I guess, the only difference, but it is a difference worth considering. So if you have any questions or you'd like to discuss your case in specific, I'd welcome you to call our firm at 732-595-1591. Again, the number is 732-595-1591. And thank you so much. I hope to see you again pretty soon. Thanks.